Good afternoon, everyone, and welcome to the fourth part of our four-part webinar series on the Convention on the Elimination of Discrimination Against Women and the 2016 concluding observations about Canada. So today we are going to look at the review of Canada's compliance with CEDAW that was undertaken in 2016 and the committee's recommendations about how Canada can improve its compliance with its international women's rights obligations. And those recommendations were released in 2016. And since then, FAFIA, Canada Without Poverty, and dozens of other organizations and individuals have been calling on the government to implement many of these essential human rights recommendations. So this is, as I said, the fourth of a four-part webinar series, and it's meant to review some of the domestic and international advocacy groups, some of the work that they've been doing. So those groups include FAFIA, Canada Without Poverty, First Nations Child and Family Caring Society of Canada. We're going to look at how they engage in relation to poverty and violence against women. And specifically, we're going to review the concluding observations from CEDAW's most recent review of Canada that address women's poverty and subjection to violence and the interconnections of poverty and women's vulnerability to violence, and Canada's need for a comprehensive response plan. So our hope is that after this webinar, you'll have a better sense of the root causes and systemic issues that result in women's poverty and vulnerability to violence. And we're going to discuss how to use the reports of international bodies and their recommendations to promote the human rights of women and how those bodies can be used in domestic advocacy and litigation. But before we get started, I want to cover a couple of housekeeping issues with you. First of all, I should say this is Karen from Canadian Women's Foundation, and we're very happy to be co-hosting this webinar today. But these housekeeping issues that you should be aware of, first on the right-hand panel of your GoToWebinar application, you'll find a box where you can type in questions. So please go ahead and use that box if you have questions or comments that you'd like to share with the presenters, or if you're having any difficulties at all with the technology. If you can't hear us, if we're talking too quickly or too slowly, just let us know. I'm going to be watching that question box. I'll do my best to answer you throughout the session. And once the presenters have finished their presentations at the end, I will read out some of the questions that you've been posing throughout the sessions, and we'll do our best to make time for the presenters to answer you. Secondly, on that same panel on the right-hand side, you'll see a section that's called Handouts, and there you can download a couple of handouts for your reference. One is a PDF version of the slides that we're using today, and the other one has a number of links to resources that are related to the discussion. And the third thing is that you should know that this webinar is being recorded, and we will share the recording with everyone who's online with us today and who registered once the webinar is over. So we have had a tremendous turnout for the first three sessions of this webinar series. We did one in January, one in February, and one in March. The first webinar that we did just gave a simple overview of CEDAW and how non-governmental organizations can participate in the CEDAW process. And the second one, the presenters reviewed recommendations that were specific to Indigenous women and girls. And in the third session, we discussed how government inaction on civil legal aid hurts women and how the criminal justice system harms, further marginalizes, and victimizes and criminalizes women. And you can find links to those webinars on the handout that's attached if you would like to watch them if you weren't with us for those sessions, or you can email me. My email address will be at the end of the session, and you can ask for those recordings as well. So this is the final webinar in this series. So before we hand things over to our presenters, I'd like to introduce you all to our amazing panel of speakers. Michelle Bies is the Legal Education and Outreach Coordinator and began work at Canada Without Poverty in May of 2014. Michelle holds an Honours Bachelor of Arts with a specialization in Religious Studies and a minor in English, as well as a law degree from the Faculty of Law. Both of those degrees are from the University of Ottawa. She has had extensive professional experience working for marginalized groups through casework, research, and community legal education. And her particular areas of interest include support for women, persons with disabilities, recent immigrants, and persons living in poverty. And Michelle is a human rights lawyer, and she was called to the Ontario Bar in 2014. Our second presenter is Anne Levesque, who is a bilingual lawyer and has practiced in the areas of employment, human rights, and public interest law. She has worked with a wide range of equality-seeking groups, legal clinics, and non-for-profit organizations on test case litigation, interventions, and law reform initiatives. Anne is currently chair of the Human Rights Committee of the Council of Canadians with Disabilities and sits on the steering committee of the Feminist Alliance for International Action. Anne is also the co-director of the Law Practice Program at the Faculty of Law of the University of Ottawa. And she holds a law degree from the French Common Law Program at the University of Ottawa and a master's in International Human Rights Law from Oxford University, where she studied as a Ricard Scholar. Next is Suzanne Dunn. Susie's the coordinator of the Canadian Feminist Alliance for International Action and another lawyer. She was called to the bar in 2016 and is currently a Master's of Law candidate at the University of Ottawa. As a research fellow with the Equality Project, she examines how law and policy can help create equality-enhancing spaces for young people online, with a focus on preventing technologically facilitated violence against girls and other marginalized youth. She was the recipient of the 2016 Shirley Greenberg Scholarship to pursue feminist research and advance women's equality. And finally, Laura Kerner-Yo is a steering committee member of the Canadian Feminist Alliance for International Action, and she's involved in FAFIA's women's rights reporting to the UN treaty bodies, as well as FAFIA's domestic initiatives through the Campaign of Solidarity with Aboriginal Women and the Step Up for Women's Equality campaign. Laura is in her final year of law school at the University of Toronto Faculty of Law, and I believe she just finished her final year, so congrats to Laura. And she has a bachelor's in political science and a master's in international human rights law. And she's worked with human rights organizations in Canada and the United States, including Justice for Girls, Human Rights Watch, West Coast Leaf, and Physicians for Human Rights. So welcome to our distinguished panel, and with that I am going to turn things over to Laura to start our presentations for the day.
Thank you, Karen. So in terms of an overview, I'm going to provide just a brief review of CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women. Michelle is going to introduce Canada Without Poverty, as well as speak to the issue of women in poverty in Canada's treaty obligations, as well as connecting to CEDAW's concluding observations on the issue of women's poverty. Anne is then going to speak to the issue of violence against women and its connection to poverty, and speak specifically about domestic advocacy and litigation. And then Susie is going to wrap up speaking also to issues of domestic advocacy, and then there'll be a time for questions and answers. Okay, so So FAFIA and Canada Without Poverty are two organizations, among many others, that advocate in the international arena, so at the United Nations principally, for the advancement of women's rights in Canada. Canada is a party to different international human rights treaties, including CEDAW. And so the reporting process is ongoing. So organizations such as FAFIA and Canada Without Poverty tend to be advocating almost on a yearly, if not every couple of years, as the periodic process occurs for the different treaty bodies. And the treaty review process is a principal function of treaty bodies. They have other functions, such as undertaking inquiries. They also hear individual complaints, and they also write general comments, which is a form of the committee's interpretation of articles of the treaty in which they oversee. There are recommendations that are made after a treaty body reviews a state's compliance with the treaty. So for Canada, for example, these sets of concluding observations include recommendations on how Canada can ultimately improve its compliance with the human rights obligations it has bound itself to under that treaty, and really minimize the gap in the domestic implementation of those international human rights standards. In our first webinar, we spoke at length about CEDAW as well as the treaty reporting process, and there are links to the first webinar on the Canadian Women's Foundation website that people can review if they'd like to. So these are just examples of the submissions that both FAFIA and Canada Without Poverty submitted to the CEDAW committee in October. Pardon me, this would have been in September that we submitted, or very early October when we submitted these reports prior to Canada's review by the committee in late October. And then the concluding observations that we'll be speaking about today were released in late November 2016. Okay. So Michelle.
Okay. Hi, thanks Laura. So Michelle Bist here from Canada Without Poverty. So to give you a bit of context about the organization I work with, Canada Without Poverty, we were founded back in 1971 as a result of the first the Poor People's Conference in Toronto. We are a leading national anti-poverty organization, and in fact, some of you might know us by our former name, the National Anti-Poverty Organization, or NAPO, which we changed to be Canada Without Poverty in about 2009, I believe. We work to represent low-income populations, and one of the ways that we primarily do this is by amplifying the voices of people who are living in poverty. Many of our members are living in poverty, and one of the things that's, I think, kind of neat about CWP as an organization is that our board of directors is made up entirely of people, since 1971, of people with the direct personal experience of poverty, either in childhood or as adults. And we really seek to understand poverty and to really spread the message that poverty is fundamentally a violation of our international human rights obligations. And so that means that we seek to provide meaningful and effective representation of people living in poverty in policy making, in different government decisions to ensure that the voices of people living in poverty are heard. Another big piece of our work is to promote a better understanding of the lived experience of poverty in Canada, to address stigmatization and discrimination. So whether this is in the private sector, for example, as many of you might have experienced in the past, there's one really good example of about 3 years ago where a newspaper, the Windsor Star, had published a piece about how people who are street involved are scum. They are, the analogy that was used was oh gosh, I'm forgetting my words, but was as vagrants that should be eliminated. And we did a lot of work talking to this newspaper and making a big public education point about the fact that this was such a hateful thing to say about a group of people living in poverty who were already so very stigmatized and discriminated against. So we've approached poverty from this perspective. Okay, so I'm sure that if you're taking this webinar, you don't need me to necessarily point out the connections between women and poverty, and the fact that women so significantly experience poverty in Canada, not to mention the intersectional disadvantage point, the fact that Indigenous women, women with disabilities, elderly women, single mothers, racialized women, immigrant women, women with disabilities in there, all experience poverty in really significant numbers. And we look at poverty very much from this perspective that it's a failure of governments in Canada to implement women's economic and social rights. From this perspective that many of these underlying conditions of inequalities experienced by women are rooted in this failure of governments. And we require a human rights approach that recognizes that poverty is not a personal failure, but something that is driven by many systemic causes. It's not a failure in an individual's inability to pull up your bootstraps. It's something that has, again, systemic causes, and something that we are legally responsible to address. And it takes us from this us and them mentality, a human rights approach, and it makes us think about our responsibilities, our obligations, and it empowers those who have been so marginalized. So when we're talking about international human rights and people living in poverty, and women in particular who are living in poverty, sometimes I'm asked, what kind of international human rights are we actually talking about? Because in Canada, and I'm sure Anne will go into this quite a bit in her discussion, in Canada, in domestic implementation, we find that there's not a lot of ways that we really jump on this understanding that poverty is fundamentally a violation of human rights. And it's actually covered by quite a number of international human rights obligations and treaties that we've signed. And so it includes things like civil and political rights, which are things like the right to life, freedom of speech, but really the right to life is one of those really fundamental ones here. When you consider the number of people, especially who are street involved, who die from exposure in Canada, in a country where we have one of the highest gross domestic products in the world, it's impossible to not see that violation of the right to life that exists for people in poverty. But there's also economic, social, and cultural rights. And these, I think, often get underscored by policymakers. They don't get brought up in the main discourse. And that includes things like the right to food, the right to housing, the right to health, and an adequate standard of living. And I often bring up when talking about these rights that these economic, social, and cultural rights are not a new thing. Often, when speaking with policymakers, they point to economic and social rights as new rights. But in fact, these economic and social rights, the right to an adequate standard of living, have gone as far back as the Declaration of Human Rights back in 1948. Article 25 specifies the right to an adequate standard of living. And what's really interesting, I find, is thinking about the context of the Declaration and where these rights came from in the first place. And the mention of economic and social rights in Article 25, I think, is so critical. Thinking about this context that, the whole world was coming out of the Second World War and looking at the atrocities that were committed and considering what is it that we want to be as a world. And out of that came the Declaration, Article 25, which protected these economic social rights. Another covenant that's really important for this discussion, and I point to these covenants, CEDAW, of course, being so critical to these, but other ones as well that protect the rights of women who are living in poverty, and where Canada has again and again been told that we're falling short on our obligations for women living in poverty. There's also the Covenant on Economic, Social, Cultural Rights, which we ratified in 1976, which points really specifically to our economic and social rights, especially for marginalized groups, including women. And these obligations for economic and social rights fall really to all levels of government. That means provincial, territorial, municipal, and federal. And just to give some context as well to how it is that governments are supposed to fulfill these rights, the expectation is for what we call progressive realization. So this idea that governments always need to be taking small steps forward, creating a poverty strategy, creating a housing strategy, creating a gender equality strategy, continually taking steps forward. We don't have to go from from 4.9 million people in Canada living in poverty to 0 people living in poverty overnight. The idea is we just keep moving forward. But at the same time, especially for wealthy countries, we have to be dedicating a maximum of available resources that we have. That means that when we're budgeting, we have to ensure that our human rights obligations are at the top of the list in terms of priorities. So how has Canada been held accountable for our human rights obligations? Well, we've actually had a couple of treaty body reviews over the past couple of years. The CEDAW review, I've included a couple of photos here. As Susie and I think, or maybe Laura had mentioned, Canada Without Poverty and FAFIA were both in attendance at that CEDAW review. So you can see there's a picture of a group of very cool women and male allies around a table. And there we are planning our submissions as civil society organizations and our work at the CEDAW review. But there's also been quite a few other ways that we've held Canada accountable for economic and social rights of women. So there's treaty body reviews. Other than CEDAW, for example, the Committee on Economic, Social, and Cultural Rights, which met in February 2016. And you might be wondering who actually sits on these committees. Who is this UN body who sits there? And what it is it's made up of independent experts from a whole variety of countries. And in these reviews, these experts ask Canada how we're faring in terms of things like, for example, creating a rights-based national anti-poverty plan to address women living in poverty. And then civil society has a chance to engage with these committees and really inform these questions going forward. And at the end of these sessions, we get these concluding observations. And as many of you know, especially those of you who have attended the other sessions, in October, there was the meeting of CEDAW. There were some major themes that came out of this review that I think is really important for those of us, especially those of us working in the violence against women or women in poverty sector, where issues like childcare, the need for a poverty strategy, housing and homelessness for women, social assistance rates, and their incredible inadequacy in this country for women came up within the discussion. And the last piece I wanted to touch upon here is we also have another United Nations mechanism I wanted to point us to, and that is the role of United Nations special rapporteurs. And this is a special procedure within the United Nations. There's 42 thematic special rapporteurs, and what their role is they cover rights like food or housing or freedom of speech. And what they're required to do is travel to countries across the world and report on how countries are doing on those specific rights. And then secondly, they produce thematic reports on how countries can, to help them kind of dig into specific rights. One thing that's kind of neat about Canada Without Poverty is that our executive director is also the United Nations Special Rapporteur on the right to housing. So I flag that if you ever have some questions about what the Special Rapporteur on the right to housing does, please don't hesitate to ask. Okay, and so last but not least, I'm just going to touch upon some of the concluding observations. I think that Susie's going to go into these much more in depth in a moment. But one thing that really came out of the review of Canada at CEDAW was this idea that the Government of Canada's current approach to poverty is piecemeal. And it has to do with a lot of functions of emergency responses to short-term manifestations of poverty. So when the government works to address poverty, they do things like open food banks, or they create shelters, they create emergency responses. But what's lacking is this holistic approach all across the board, and understanding a rights-based approach, and understanding how all kinds of different policies intermingle and work together. And the CEDAW committee was quite concerned about this. They saw that it kind of perpetuated these patchwork systems, that a lot of initiatives were not connected through a rights-based framework to eliminate the root causes of poverty. And there was a real understanding that private and public actors like food banks and private and institutional donors who support things like food banks are really filling the gaps where the government isn't creating holistic policies, programs, and laws. So this was a really important, I think, overarching approach, but I will now pass it on to Susie, who I believe will be walking us through some of the more specific concluding observations.
Thanks, Michelle. As Michelle was saying, following each of these reviews, the committees come out with these really excellent recommendations on how Canada can further implement women's rights. And in the previous sessions, we've covered other topics, but today we're going to go over poverty and violence. So I'm just going to highlight a few of the recommendations that came out that spoke specifically to those issues. And I think the ones that were released this year were really good, and they're ones that people like Michelle can work with. And so I'll just read out a few of the ones that we have here. So the committee recommended that Canada develop a national poverty reduction strategy and also a national housing strategy. And they recommended this in order to protect all women. But they recommended that Canada focus on the most disadvantaged and vulnerable groups. And throughout the recommendations, you can see that they focused on low-income women, Indigenous women, women with disabilities, women who really often suffer from poverty at higher levels than other types of women. An issue around poverty that came up was about First Nations reserves, and women weren't actually as active in engaging with the water systems management and regulations as they should be. So the committee recommended that Indigenous women be more involved in that process. A large number of women who are impoverished in Canada are living on social assistance, and as many of you will know, our social assistance levels are quite low, and they're very difficult to live on. Most people who are living on them are living below the poverty line, and so CEDAW recommended that Canada specifically earmark sufficient funds for social assistance when federal transfer payments are going to the provinces and territories, and this is in order so that women can live like an adequate standard of living when they're on social assistance, something that they can live healthily on and live well on. They also recommended that Canada improve the number of affordable childcare facilities and the affordable and adequate housing that's available to women. And as many of you know, childcare is deeply linked to women's poverty in Canada. And in areas like Quebec, they've done a bit better where they've got less expensive childcare available to women. And in that province, you've seen greater increases of women going back into the workforce and living on adequate incomes and being able to support their families in ways that they couldn't have when they didn't have access to affordable childcare facilities. And so one of the recommendations was to increase that. I'm going to touch a bit on violence against women before I go over some of the other recommendations, because poverty is so deeply interconnected to violence against women. FAFIA and the Canadian Association of Sexual Assault Centers submitted a report to CEDAW that touches on these issues. So if you're interested in learning more about it, on the handout that we've got, you can link to our report, and it's got an in-depth research on that area. And some of the things that we highlighted in that report were that hundreds of women are being turned away from shelters every day when they're fleeing violence because these shelters just lack capacity. There isn't enough funding for the shelters that do exist, and there isn't enough shelters across Canada. Rural women and northern women really feel this. They often don't have direct access to shelters in their communities, and they're also experiencing some of the highest levels of violence, and so they've got a bit of this double disadvantage by not having access to shelters. And women who can't afford additional housing if they're living in a violent relationship, so if they're living on social assistance or if they don't have other options for housing, they're often forced to stay in abusive relationships because of their poverty. And the lack of affordable housing in Canada is one of the main reasons why women are staying in these violent relationships. And so that's just one of the clearest direct links to how poverty impacts violence against women. And one of the issues that we brought up to CEDAW was that women who are on social assistance who have children and are living in violent relationships, they're at risk of losing their children because of the violence, because their houses are considered unsafe or unhealthy environments for children to live in. And so when children are removed from the house because of violence, women who are on social assistance who are in a family unit then lose the family unit because they don't have their children, and they're put into single unit households. And then when they try and get their children back after, say, they've left the violent relationship, they're actually not able to get their children back because they no longer have adequate housing, and they don't qualify for family housing anymore because they don't have their children, which puts them into this impossible loop of being unable to get adequate housing to get their children back. And the statistics for violence against women are tragic. You can see on this slide that 6 out of 10 female homicide victims have a history of family violence. And Indigenous women in particular are disproportionately represented in vulnerability to poverty, and they're also disproportionately represented as homicide victims in Canada. And for many Indigenous women, as we mentioned before, they live very far away from some basic services like shelters or police services. And if they need to access support, they actually have to leave their community in order to get that support. And for women who are living in poverty, who don't have access to transportation, such as their own vehicle or even buses, they often have to hitchhike. And in Canada, in northern BC, we saw the highways of tears and how much that poverty and that inability to transport themselves safely impacts women, and many women were going missing or being abused while they were hitchhiking in that area of Canada. And it's this insufficient financial resources that women have that play a significant role in perpetuating violence against them. And again, government funding for these types of services that support women like this is so low, and so sexual assault centers, shelters, other services are grossly underfunded, and so women can't actually get access to these services. And many of you who are joining us for this presentation might have noted that Vivica Ellis was going to be presenting for us, and I just wanted to do a bit of a shout out to her today, because the reason she's unable to come is because her organization, the Single Mothers Alliance of BC and West Coast Leaf, have actually filed a charter challenge about women who are living in violent relationships and their inability to access adequate legal aid. And so I recommend that all of you look at this charter challenge. It's very interesting. If you go to westcoastleaf.org, you can see the challenge that's been brought, or if you're on Twitter, you can look up hashtag legal aid for women, and that's legal aid, the number 4, and then women. So I recommend you looking at their work. They're doing excellent work about violence and poverty with women in Canada. And so returning back to some of the concluding observations that were made by CEDAW and some of the recommendations, I've highlighted a few of the ones that speak to violence against women, and these are ones that your organizations can use to advocate on behalf of women. So CEDAW recommended that Canada enhance its efforts to combat all forms of gender-based violence against women, including domestic violence, sexual violence, and paying particular attention to marginalized women and Indigenous women. And they recommended that one of the ways that they combat this violence is that Canada work harder on destigmatizing victims of violence and helping provide appropriate training for judges, prosecutors, police officers, and other law enforcement officials who work with women who've experienced violence in order for them to get adequate support. And as many of you know from the Missing and Murdered Indigenous Inquiry, Canada's had a lot of issues around having violence against women being properly investigated, and so CEDAW has recommended that Canada take better steps to ensure that all cases of violence against women are thoroughly investigated. They've also recommended that Canada adopt a national action plan that combats gender-based violence against women, that they increase the number of shelters available and strengthen services for victims of gender-based violence, and also begin collecting adequate data on the types of violence that women are experiencing, so we can see trends for what type of women are experiencing what type of violence in order for us to provide better, for Canada to provide better services to them. And one of the interesting recommendations they made also was on cyber violence. And so cyber violence is a new form of violence that women are experiencing in Canada and are struggling to find legal solutions for. And CEDAW recommended that Canada provide an adequate civil remedy for victims of cyber violence, and also reintroduce Section 13 of the Canadian Human Rights Act, and that section used to provide a remedy for women who experienced violent speech online. And finally, the last observation that I'm going to speak to is one that's specific to Indigenous people. And so the CEDAW committee recommended that Canada develop a specific and integrated plan to address the socioeconomic conditions affecting Aboriginal women, because Aboriginal women face some of the lowest employment rates in Canada, the lowest income rates in Canada, and some of the highest rates of violence. So I think that that was a very important important recommendation that they brought up. So next I'm going to pass this off on to Anne Levesque. And Anne Levesque, as was stated earlier, is an amazing international human rights lawyer. And she's not working specifically with CEDAW, but she works with other important international human rights treaties and has used them in litigation. So she's going to speak a bit to how you can use these recommendations and treaties for your work domestically and in litigation. So I'll pass it off to Anne.
Thank you, Susie, for the kind introduction and the very rich overview. So I'll be speaking in my capacity of counsel for the First Nations Child and Family Caring Society. And of course, I'd like to acknowledge Dr. Cindy Blackstock, who's the Executive Director of the Caring Society, and my colleagues, the legal team, David Taylor, Sarah Clark, and Sébastien Gramont, who are also co-counsel on the matter. For those of you who don't know, the Caring Society is a national nonprofit organization committed to research, training, networking, policy, and public education on behalf of First Nations children that serve the well-being of First Nations children, youth, and families. It's the only national organization with a specific mandate to promote child welfare of First Nations children, families, and youth. And the Caring Society, not by its own willingness, but was forced to file a human rights complaint against the Government of Canada in 2007 after trying to advocate the government for the inequitable child welfare services on reserve. So I'll be speaking a bit about that case, but more specifically about how we used international human rights law to bolster our legal arguments. So first of all, international human rights law and how it can be used domestically. I see my screen is going. Oh, here it is. So how it can be used domestically as an advocacy tool in litigation. I'll be speaking specifically to litigation, but I think the Caring Society case also provides good examples of how it can be used as an advocacy tool or for education. With regards to the first point, education, what it does is, and specifically the concluding observations of treaty bodies, provide an overview or a glimpse of the state of human rights in Canada and how it compares or measures up to international standards. And that, in turn, becomes very helpful in advocacy. As Michelle said, when you're framing an issue or a claim, an advocacy claim, as a human rights issue rather than a policy issue, it adds legitimacy. It's not an issue of a personal failure or a policy discretion. It's really a matter of legal obligations, and this is particularly important, I think, in the context of positive obligations, but also socioeconomic rights. So it adds teeth to the claims, and then the focus becomes of the consequences of failing to honor those legal obligations. And finally, the last point is in domestic litigation. So when you're doing court cases in Canada, how you can use international law, and I'll speak a bit to that. The first point that I wanted to make clear is unfortunately for now, the concluding observations of treaty bodies are not independent, standalone causes of action in Canada for now. And maybe one day that won't be the case. But for now, if you have, for example, CEDAW making certain recommendations or findings of non-compliance, you can't in turn take those to Canadian courts and sue the government for not acting on them. What you can do, however, as long as you have another legal hook, is you can use those findings to bolster existing claims, specifically with regards to the Charter of Rights and Freedoms. And there's good case law on this, that the rights provided in the Canadian Charter of Rights and Freedoms should be presumed to provide at least the similar protection as those in international human rights documents. So it's not always the case, but it's what human rights advocates should be arguing before the courts. And alternatively, if you're not involved in a charter litigation, it's also very helpful in human rights litigation. So when you're making claims of discrimination, for example, and that's particularly what happened in the Caring Society case, to inform the tribunal's understanding of Canada's and the government's obligation with regards to non-discrimination and the right to non-discrimination, and also with regards to remedy. How can tribunals tell the government what to do? And in those cases, I think once you're successful, it's very helpful to have and to cite the concluding observations of treaty bodies to help the tribunal understand context, but also appropriate remedies to address the root causes of human rights violations. And of course, other legislation, and there's case law on this as well, that international human rights law can be used to inform our understanding of what legislation means in Canada. So why argue international human rights law? And there's often a joke in human rights lawyers that if you have a really good case, you argue the facts. If you have a so-so case, then you'll argue the charter. But if you have a really bad case, that's when you argue international human rights law. And I don't necessarily agree with the joke, but the principle is that in general, courts are quite reluctant to apply international human rights law principles. So the question is, why do we do it? And I would just say in reply to that joke is that I think it contributes to the message that international human rights law is law. We need to continue to pound that message, the same drum, to say that this is law, it's binding, and Canadian courts need to apply it like it is law, that it's not a matter of rights, it's a matter of charity. It's not a matter of charity, it's a matter of rights. And to hold Canada accountable for breaches of international human rights law, and domestically, internationally. And I'll speak a bit to the symbiotic relationship that can be formed between those two forums. And finally, I think international human rights law, and there is examples of this, there are examples that it does expand the scope and enriches our understanding of rights that are already guaranteed in Canada. And I think a good example of this is, in fact, the Caring Society case. So for those of you who aren't familiar with the case, it's a human rights complaint filed by the Assembly of First Nations and the First Nations Child and Family Caring Society back in 2007, alleging racial discrimination, that the government was racially discriminating against 155,000 First Nations children on reserve in the provision of child welfare services. So the complaint was filed to the Human Rights Commission in 2007, and the government of Canada fought that complaint tooth and nail against the Caring Society and the AFN's Pro Bono Council. And one of the legal arguments made by Canada was that First Nations children receive child welfare services from the federal government, and all other kids living off reserve of other races receive services from provincial governments. So in this case, it cannot be discrimination. We cannot, First Nations children cannot expect to be compared to other children because those services are provided by other levels of government. So they were making what they called it in legal terms, as they were saying that cross-jurisdictional comparators are not permitted. And they made a slippery slope argument saying that this would result in people in Alberta maybe suing the government of Alberta because they didn't have subsidized child care like in Quebec. They just said that they're, Indigenous people in Canada are in the unique position where they're the only ones receiving these services, so this cannot be discrimination, because there's no one really to compare them to. The federal government only funds child welfare services to children on reserve. And in that case, we were really grateful that Amnesty International intervened with this case. In our case, they sought interested party status and made the argument that was very helpful to inform rights already existing under the Canadian Human Rights Act, but the right to non-discrimination, but to inform our understanding the application of that right. And what Amnesty International argued is a well-known principle in international human rights law that rights are guaranteed to people residing in a state, and how a state chooses to structure itself constitutionally is not an excuse or a shield to those rights. So the fact that Canada federally funds child welfare services to First Nations children, and the rest of Canadians receive those services from the province, should not in any way be used to undermine Canada's international human rights obligations. And that was used to inform also the understanding of the Canadian Human Rights Act. So because of international law and because of our reference to it, as it helped inform the tribunal's understanding and also their application of the scope of the rights guaranteed under that legislation. The tribunal also articulated a definition of international of equality that was consistent with international human rights law and domestic law. So they saw them as two similar and two obligations that Canada had, and that Canada's obligations to non-discrimination included its obligation to take into account the historical, geographical, cultural needs of First Nations children. So that's a bit how we did it. Just briefly on education and advocacy, I think again the Caring Society case is a brilliant example of how international human rights law can be used as a tool for advocacy. I would encourage you to visit the website www.fncaringsociety.com. But really the international human rights law has become a pillar to the Caring Society's advocacy strategy, and it's being used to educate children about their rights, and it changes the discourse, and children see themselves as rights bearers. They organize protests, they write to the Prime Minister, and they're not asking for charity, they're asking for the enforcement of their international human rights law, to their international human rights. So if any of you happen to be in Ottawa, and every Valentine's Day we organize Have a Heart Day, and you will see the impact of international human rights on these children. They really do consider themselves rights bearer, and they are holding the government account. And that's really something that they've internalized through the advocacy strategy. That is really a rights-based approach. So that's about it. I would just conclude by encouraging you to visit the Caring Society's website as examples of, I think, effective domestic advocacy based on international human rights law. And of course, if you have any questions, not to hesitate to contact me or to type in now.
Awesome, thank you, Anne. So FAFIA, I would just encourage to reiterate, Anne, I think everyone should check out, if you haven't already, the First Nations Caring Society case and the First Nations I'm a Witness, which has all the documents pertaining to the matter, so you can read the decisions, you can read the legal argument from the Caring Society's fantastic legal team that sets out the international law and standards that Anne was speaking to, so it's really, really important. And then another example of domestic advocacy would be the Step Up for Women's Equality campaign. And this campaign was started by FAFIA following the CEDAW concluding observations being released in November. So the Step Up for Women's Equality was formally launched in January. And we have over 100 signatories, individuals and organizations across the country that are calling on Canada to take action and to actually implement the recommendations from the CEDAW committee. If you would like to participate in this campaign on social media, you can find a link to a Dropbox folder containing infographics, and then you can post on social media with the hashtag Step Up for Women CA or Step Up for Women Canada. And with that, I think we're going to move into questions and answers. So, Karen, if you want to, yeah.
Absolutely. Thank you so much, everyone, for your amazing presentations. They were really rich. I do have a couple of questions. The first question, oh, and there's a couple coming in here. Recommendations made by the CEDAW committee are viewed as soft law. So the government can easily opt out of recommendations that are made to it. So how do you address the issue of soft law? So maybe I'll leave that as the question first and break this up a little bit. So yeah, just on the issue of soft law, what are your thoughts?
Maybe I'll take a stab at that. I think that we just have to make a distinction between whether it's law and whether it's domestically enforceable law. So whether it's soft law or hard law, the recommendations, in my view, constitute strong evidence of violations of rights. Though that is law, in my view. The question then is about how do you enforce it, and I think that's a separate question and a very good one. But I would just stress also that the same dilemma poses itself in domestic cases. When you have a successful decision, you win in a charter case, for example. So legally, you have a legally binding decision, but enforcement is obviously always another challenge. So I would just encourage advocates to not to kind of not downplay, but not to see the recommendations as law and as findings of violations, and to advocate in that way. And then the question becomes, how do you enforce those findings of violations? And that would be up to the strategy of every group and every advocate, whether it's through the courts, through advocacy, through law reform, or through education. So yeah, I hope that answers the question.
I can also step in here, Anne, although I think your answer was really excellent. This is Michelle here. So just to kind of build on what Anne was saying there, in terms of enforcement and implementation, I think often, especially as people who are within the legal world, and I know I'm guilty of this myself, considering, first of all, this really significant dichotomy that we know about in law school between soft law and hard law, and how do we use the courts, and how do we have a specific action. We kind of ignore this whole law reform side and this advocacy side, for lack of a better word, this advocacy side. And I think that there's a lot of value in the concluding observations that we get out of these committees, specifically to encourage policymakers to create laws and policies that adhere to these international human rights obligations. So there's other ways, I think, of using these recommendations, not just within court decisions, but also through implementation, and encouraging policymakers to not so much consider them within this soft law, this international group is, this UN group is telling me to do one specific thing, and it's not really a legal obligation, and we hear that a lot, but to really get them to consider other avenues, and using the media, using public opinion, and using this as a way to show, yes, this is a violation of human rights that exists, and we have the United Nations that has recognized that this violation exists.
Hi, this is Laura, just stepping in, just very briefly, just to go to sort of the technical aspects of how hard versus soft law is understood under international law, because the statute on the International Court of Justice sets out the sources of law. So treaties, conventions such as CEDAW is a form of hard law under international human rights law. so output of the treaty bodies, such as concluding recommendations, such as inquiry reports, such as general recommendations or comments, those are forms of jurisprudence of the committee. So they're technically, like, they are authoritative. So I don't know if I wouldn't categorize the recommendations as soft law per se. They aren't legally binding and they're also not enforceable, but they're an authoritative statement coming from the treaty body, which is really like the world's experts on what states need to do to comply with these international obligations. And so, yeah, so I would just caution against calling them soft law. They're definitely not binding. So in that way, they are quote unquote soft, but technically they're a form of jurisprudence speaking to like an instrument under international law, which is a hard law.
Okay, great. Thank you for those answers. We have another question here from Maria, who wants to know, because Canada is proposing a poverty reduction strategy, how can legislation and laws be integrated to ensure that poverty and violence against women are both addressed comprehensively? Any thoughts?
Oh, I can take this one. This is Michelle again speaking. We've been doing a lot of work on the Canadian Poverty Reduction Strategy, in particular to ensure that the government is taking into account our human rights obligations. So what that means is that they would take a rights-based approach. Well, that's what we're hoping that they'll do, to take a rights-based approach, which there are guidelines from the United Nations, in particular from the High Commissioner on Economic and Social Rights, and how to integrate a human rights-based approach into a poverty strategy. And there's lots of different aspects of this that we're really working on the government to include. Whether or not they will, it remains to be seen, but it includes elements like ensuring that people with lived experience of poverty are involved in consultations, that there are targets and timelines within a poverty strategy, and really fundamentally, that there is some sort of accountability or review mechanism that ensures that those who are living in poverty and who are the most marginalized can actually access remedies if the poverty strategy doesn't work for them. This is a piece that I'm not sure that the government is actually going to take up, but we're really, really pushing them to do that. And really fundamental to all of this is this intersectional approach and understanding that the poverty strategy can't exist in isolation from, for example, the child care framework or the housing strategy, or a gender equality framework. All of these different pieces need to work in collaboration with each other, and that's part of a human rights approach.
Okay, thank you. Now, there's another question here that is sort of specific, and so I'm going to do my best to interpret the question, and if the person who asked it doesn't think that I've done a good job, please definitely type in. But basically, this question is talking about non-state torture and the Canadian government's decision to refer to non-state torture as being assault. And I think that they're suggesting that this would be in violation of Article 5 of the Universal Declaration on Human Rights. And so the question is, if women or girls endure non-state torture and then they don't have the legal right to denounce that kind of victimization in the courts, what suggestions would the panelists have to mount a legal argument about this as a human rights violation?
I can take a stab at that. It's Anne. Well, I would say that I see in Section 7 of the Canadian Charter, which guarantees the right to security, I see the potential there to create a cause of action or to protect women against gender-based violence. There are currently legal challenges to that. Currently, the manner in which courts have interpreted Section 7 of the Charter has been much focused on negative versus positive obligations to protect security. It's been focused, and most of the case law has been focused on cases where the government is the perpetrator of the breach of the right to security rather than a non-state actor, and there are some exceptions to that. For example, the Bedford case, which involved sex work. In that case, the government was found, in breach of the right to sections under Section 7, the right to security, even though it wasn't the one committing the violations of the right to security. But there was a finding that the government's legislation was causally connected. But I would like to see one day, and this could be for feminist advocates to argue that an expanded interpretation of Section 7 would include the positive obligation on the state to protect women from gender-based violence. And that's consistent with international human rights law. It's consistent, with what the Special Rapporteur on Violence Against Women has said. The Special Rapporteur on Torture has said an understanding of security that includes security in the private sphere. It includes protection from partners, from non-state actors, and it includes a positive obligation to protect and then to remedy, to protect women from violence, and then to provide compensation when there are breaches. That's maybe it's a very expansive understanding of Section 7. It's currently not really in check with what the courts have said Section 7 is meant to include, but I think that if progressive advocates could make that argument, I mean, my understanding of a feminist interpretation of Section 7 certainly includes protection from violence against women. I hope that's helpful.
Thanks very much, Anne. And that does bring us actually to the end of the questions that were submitted with perfect timing. We're just at the top of the hour now. So I'd like to thank Anne, Michelle, Susie, and Lara for your wonderful presentations today and your attention to the questions that were asked. We really appreciate that effort, and thanks to all of you for joining our webinar session today. As I mentioned at the beginning of the session, there will be a link to the recording circulated. You can feel free to share that with your colleagues on social media and help sort of share this knowledge around. But yes, we will leave it there for today. So thank you very much again, everyone, for your participation.